Assalamu alaikum and good afternoon to all of our viewers who are seeing this live video program from Bangladesh and abroad. Basically, in this present scenario of Bangladesh during this COVID-19, e-judicial system is a very burning issue, and considering that point of view, uh, uh, the BD Law News, we arranged today's program on the issue of e-judicial system, and our guest is Mr. Satya Ranjan Swain. He is a practicing advocate in Delhi High Court. He would try to enumerate today about the e-judiciary, what is e-judiciary, and what is the system they introduced in India, basically in Delhi High Court, and some questions maybe the history of their judicial system, system of their country's judicial system, procedure of e-filing of suit, hearing of suit, disposal of suit, pronouncement of judgment, what types of remedies are usually given by them, how courts are deposited, etc. Hopefully, this video program would be very helpful for us, basically for the lawyers who are practicing in Bangladesh. And I would request Mr. Parvez Rana, who is also a practicing advocate in Bangladesh Supreme Court, to host the program. And till then, thank you so much. Please enjoy the program, and hope it would be a very much pleasure for us to have Mr. Satya Ranjan Swain. Thank you. Okay, please start, Mr.
Thank
Parvez
you.
Rana.
Thanks a lot. Thanks a lot, my learned advocate friend. Hello, Satya.
Yes, hello.
I'm not going to introduce Satya Ranjan Swain. He is my friend, and last we met in Delhi, 2018, right?
In the Bangladesh Independence Day celebration.
Right. Today, I'm not going to introduce you in this program. You will introduce yourself, and we will discuss on e-judiciary, that is a current issue of Bangladesh. We are going to enter into a new large scale of e-judiciary. So first introduce yourself, and then we will start our program.
Well, I'm an advocate practicing in Delhi and majorly in Delhi High Court. I'm a central government senior panel counsel and a standing counsel of AIMS. So this is briefly my introduction. And as far as e-judiciary is concerned, well, in India, we call it e-courts. And it is a popular project of the Supreme Court of India. And it is widely being used. And this is what it is.
Okay. You started e-judiciary in 2014, right?
Yes. It is actually a committee, e-committee of the Supreme Court of India, which was formed in 2014
Right.
under the chairmanship of then CJI. And thereafter, it was the committee's recommendation which conceptualized this concept of e-judiciary. And before I start, let me tell you one thing. When I say e-judiciary, that is different from computerized courts. When I say computerized court, I mean the courts having the computer. But when I say e-courts, I mean an online environment in which, starting from filing of the case to the final adjudication, everything is done online. And the primary intention behind this e-court project is to make it efficient, to make it transparent, to make it speedy and affordable to everyone. The right to access of justice is a constitutional right, and it is the duty, it is the obligation of the state to create an environment so that everyone who is interested or who wants to access justice can access justice. It is our endeavor to take the courts to the consumer of the justice. The lady of justice is blindfolded, and in India, she has decided to go to the doorsteps of the seekers of justice and redress their grievances. As far as its history is concerned, as I have already stated, it is conceptualized by the E Committee of the Supreme Court of India, which was formed in 2014. And it worked in two phases. Phase one is about creating an infrastructure, developing an infrastructure, and connecting the Supreme Court, various high courts, and the trial courts. It is like 14,249 trial courts, district courts. So this is what it is. And as far as the second phase is concerned, the first one is conceptualizing a common filing center, which we do not have at the present time. The second one is digitizing the documents. We are working on it. And the second one is managing the documents management system. We have already adopted it. And the last one is creation of a e-payment or e-filing system, which we are already working on. So these are the things which are in the second phase of the e-court project. And it is the High Court of Judicature at Hyderabad who first initiated this and established this e-court project, and it has it was established in Hyderabad.
I want to know that only High Court or Supreme Court established e-court?
No, the Supreme Court, the Supreme Court is also covered under that e-court project, and we are trying to go to the trial courts now. So we are doing it in a bigger scale. Yes.
Okay. Then what's about the lower courts?
Yeah, that's what I am saying. As for this e-court project, we have connected all the high courts and the district courts. So all the district courts are connected. Whatever case is filed or whatever stage it is, you can find that in the website. And in the High Court, in the Delhi High Court specifically, there is a huge application of mobile services. If you file any document, if you file any case, you will get a SMS in your phone that this is the diary number. If the file is in defect, you will get a notification that your file is under defect. And if the case is listed before the court, then you will get a notification that this case with diary number such and such is listed before so and so court, which is coming up on so and so date. So this is the way we are functioning in Delhi High Court presently.
Okay. Then there is a specific question that if you file a suit, there are some annexed papers you must submit it in the court. How you annexed the papers?
See, the original file and the annexure both has to be prepared electronically. You have to prepare it by using the Microsoft Office or the Open Office software. And you have to then convert it into PDF. All these documents has to be prepared in A4 size paper with the Times New Roman. And it has to be converted to PDF format. And if there is certain document which is not in text format, it has to be scanned by using the 300 dot per inch DPI system, and the maximum size of the file has to be 100 MB. And once it is done, you have to compile the original document, original file along with the annexures and other documents, make it one, and then file it. There is an online filing system also, and you can file it in the counter also. For this pandemic, there is a special arrangement made. You have to send it to the registrar, and there is a email ID that is provided by the High Court concerned. You have to send that to the registrar, and he will get the matter listed. So this is how we deal with regard to the original file and the annexures.
Is there any is there any opportunity to forgery of the papers?
Pardon?
Is there any opportunity to forgery of the papers?
Forgery of the papers.
Right.
Forgery of the paper. You mean the annexures is forged one?
Fraud.
That is what you are saying?
Yeah.
See, to address that, we have a system of retention of file. So, for instance, someone has forged a document and has prepared an online, file and have filed it before the court. You have to keep the originals with you till the proceedings of the case, and even after the case is finally adjudicated, it has to be kept, for the 2 years till the 2 years after the final disposal of the case. So if there is any forgery, it will be caught.
Okay. Actually, there is some confusion that how the hearing of the suit is taken place in e-judiciary, because there is a judge, there is two lawyers from different parts, there are juniors in the court, there are clients in the court. So how e-judiciary accommodated everybody in a single screen?
Look, I will tell you about the current situation, the corona pandemic that we are witnessing now, and the way the courts are functioning now. As I said, you have to send the application, the case file to the registrar. Then the case will be listed before the court. And once the case is listed before the court, the registrar and the staff, court staff, will ensure that the person who is filing the case has served a copy to the other side, to the opposite side or the other side, whatever you may call. And he or she must be having the software that is being used by the High Court. For instance, in High Court, we are using the Cisco WebEx app. So the High Court, I am told that the Delhi High Court is so proactive that if the staff is working beyond the limit, beyond the time limit that is being that is there, it is one of the most leading High Court and the most progressive High Court in the country. So once it is ensured that the other side has also received the copy of the file, then the judge, both the sides will be coming up for the video conferencing. And in the video conferencing, the petitioner, the respondent, whosoever is the party, they will plead their case, and the other side will have the opportunity to defend or keep his side of the story. Yeah. So this is how it is being done, and online dictation of order will be done by the court.
That's good. If there is any chance for data theft?
See, it is one of the issue that is being debated. Till now, there is no such issue or no such complaint made. But I believe the High Court has ensured and developed a mechanism that there will be no theft of data and no theft of identity. And yes, the threat is always there, but we are trying our best to keep our files, keep our protected data protected.
As per I know, National Judicial Data Grid through WAN, that is one wide area network, has been established for e-courts in India.
Right.
So, how you ensured the security of the National Judicial Data Grid?
See, that is a technical aspect of it. I am not in a position to say how they are securing it. But as far as National Grid is concerned, yes, all the courts are connected with the National Grid, and there is a website, e-courts website, in which you can go anytime and find how many cases are pending in which court, how many cases are disposed of, how many cases are coming up in High Court, Supreme Court, and all the courts. So this is what it is. This is the national greed.
What type of suit are filed basically here? There is a civil suit, criminal suit.
For the e-courts?
E-courts? Yeah.
At the present situation, that is in this pandemic, as far as civil suits are concerned, only the stay matters and the eviction matters were being taken up, and in the criminal matters, only the bail and the remand matters were being taken up. But recently, the High Court has come up with another order yesterday, in which it has mentioned 8 matters, starting from the matrimonial dispute to the domestic violence dispute to the eviction suit to the criminal appeals or the criminal revision or the criminal petition where the convict is in custody, quashing of criminal cases, MSCT cases in which there is a death or a physical permanent disability, ex parte cases, and all these cases are now being taken up in the e-courts, and but it has to be ensured that it is at the final stage of hearing, and both the sides were requested to supply a 5-page note, not more than 5-page note, so that the court can go through that and adjudicate upon the matter. And in case there is a requirement of any video conferencing, the court will go for the video conferencing. So this is how the matters are being heard here.
I have some data here that the Supreme Court heard 593 matters via video conferencing and delivered judgment in 215 of them.
Right, that's true.
That's the yesterday this report was published, and
right.
Normally the apex court disposes on nearly
many matters are being listed for the judgment, and many matters are being heard, and I think the High Court and the Supreme Court are doing quite well by using this facility.
That e-judiciary shorten our power to hear or move the case?
Pardon, I didn't get.
Do you think that e-judiciary, via e-judiciary, our limitation, it's a limited scope for movement of the suit? That apex court disposed nearly 3,500 cases on average a month. Where
right. You mean to say the number of matters that is being listed? Yes.
Yeah.
Yes. In a normal day-to-day situation, like in one court, there were for instance, in High Court, there are not less than 70 matters, 70, 80 matters, and I have seen courts hearing 100 plus matters in one day. But if it is e-court, it is not possible to hear so many matters. Maximum the court can go up to 25 or 30 matters in a day. So yes, in terms of dispensation and adjudication of the matters, the numbers will be less.
Then what type of remedies usually given?
What type of remedies?
Remedies.
Remedies as in all, as I said, all the criminal matters where there is a concern, there is a bail application, there is a remand application, or in the civil suit, if there is a injunction or a eviction proceeding, in all these cases, the courts are going for e-courts at this present time because of the corona pandemic.
Right. Then for filing a suit, we must pay court fees. Then
right.
How the court fees are deposited through e-judiciary?
See, there are two things. As far as payment of the fees are concerned, there is a facility for purchasing the e-court fees by the from the website of the Stock Holding Corporation Limited, which is being sold online. There is a counter of the same also in the High Court premises. There are authorized vendors elsewhere. One can purchase all those. But with a specific reference to Corona pandemic, there is dispensation of filing of affidavit and filing of court fees.
Then there are two types of court fees in Bangladesh, that is fixed court fees and other. Why the court fees are deposited? I want to say that we annex court fees in top of the petition.
Right. So the system that we follow here is, once you purchase the online court fees, there will be a code generated. The code, you have to mention it in the appropriate box, and it is in the first page of the file that you are filing. There is a appropriate box. You have to mention that code there.
Okay.
So instead of putting the code fees on the top of it, you just mention the code number. That's it.
During motion, it's a short hearing, but when we go to the rule hearing, it's a long time matter. So is it possible for e-judiciary that rule hearing it needs a long time?
See, as far as I understand your question, you are saying it is good enough for the final hearing, but for the entire trial, it is difficult, right? What I am suggesting, all right. So what I am saying is, right. What I am saying is, as far as the civil matters are concerned, companies matters are concerned, the complete adjudication can be done via, e-courts. But as far as criminal justice dispensation system is concerned, it is quite difficult there, because in criminal justice system there is a provision for supply of documents. There is a provision for presence of the accused, presence of the witnesses. Most importantly, one has to identify the original documents. One has to ascertain whether the exculpatory documents are in the file or not, if there is any material seized, if the seals were properly made or not, and most importantly, the conference between the convict and the counsel is very important. Now, how do you ensure confidentiality? There is a suppose the person is in the custody, and you go for a video conferencing meeting. Now there is a chance of the police hearing the conversation, so it breaches the confidentiality. So in criminal justice system, it is quite difficult for prosecutor, for example. For prosecutor, if there is a document which is quite old, now the prosecutor has to acquaint the witness to the old documents. Now, if you are going for the video conferencing, how do you show that? In India, there is section 280 of the CRPC, in which the demeanors of the witnesses has to be recorded by the judicial officer. Now, how do you do that? In the video conferencing, there is no way to ascertain that. Now, yes, these are some of the intricacies which needs to be addressed before completely going for the e-court system. But as far as civil service and company matters are concerned, arbitration matters are concerned, it can be dealt with in an e-court system.
Judicial system that we need electricity, we need data connection, we need broadband internet connection. So is there any technical problem?
See, technical problem as of now, there is it is not a big technical problem presently, but initially yes, and it is natural also. When there is a systematic change, there will be technical difficulties. Moreover, you have to create an awareness among the litigants, and most important is the acceptance by the litigant to the new system. So these are the technical thing. Now the court staff has to be educated. They have to be, made convergent with this new system. So these are the system, the difficulties that one system undergoes at the initial stages.
E-judiciary is a vast thing that European countries and Western countries are following this from a long since. We are
Right.
very much young in this sector. Do you think that there are any limitations in your country, especially in India?
See, limitation, as I said, in criminal justice system, there is a limitation that I have already stated. There are, in addition to that, there is the issue of cyber security that you mentioned with regard to theft of identity, theft of databases. These are the limitations that are there. But I believe the country and the judiciary is working to overcome all these difficulties and limitations.
Okay. Then, what is your opinion that how can your country get more benefits from this from e-judiciary?
My opinion as to what needs to be done, or what do
Needs to
you
be done.
want?
What needs to be done?
All right. In India, we are doing all these things that I have already mentioned, but we have to boost up our internet facilities and other things in the rural and the different distinct locations. And I believe in India, the data is cheapest in the entire world. Here, 1 GB is equal to zero point 0.2 US dollar. So we have cheapest data, and I think the government has to boost up the internet and other infrastructure so that we can, so that anyone who is in the remote corner of the country can access it. Secondly, what I wanted to highlight is creating an awareness among the young young advocates and the litigants. And the most important that I wanted to highlight is implementing this e-court system in the teaching them at the law school level. For instance, in law school, we have the moot court competitions. So why not go for a e-moot court system where there is no paperwork, where there is no physical presence of judges and the person who is arguing. So I think these are the things which will be helpful in creating awareness and making people more oriented and aware of the system.
Right. Satya Ranjan Swain, you are practicing lawyer from Indian Supreme Court, and I think that this program will help to establish a better e-judiciary in Bangladesh. We are going to establish a e-judiciary within few months in here in Bangladesh. Thank you.
Congratulations for that.
Thanks. Thank you very much for joining with us, and we will meet again.
Thank you. Thank you.
Yes, Mr. Satya Ranjan Swain, really, this was a nice presentation, and we got tremendous ideas about the judicial system in Delhi High Court, especially in India. In our life, we want to connect with you another lawyer of Bangladesh Supreme Court, if it is possible. Just I just knocked him a couple of minutes ago that if it is possible, then he was a lawyer who filed a writ petition, especially about the introducing the judicial system in Bangladesh. So I have knocked him. So please do continue, you too. I'll just go back to all of you after a couple of minutes.
Yeah, Satya Ranjan Swain. there is a data that National Policy and Action Plan for Implementation and Communication Technology in Indian Judiciary that was established in 2005.
Right.
Then E-Committee submitted their proposal to the government on 2005. Then it started from 2014. That why a long time needed?
No, see, this recommendation of the E-Committee was approved by the Cabinet Committee of the Government of India only in 2007. And the present form that you are seeing now, it is being approved only in 2010. So when there is a new system coming up, it takes time. And I think it is not a very long time. And since there is a in India, it is a big country, and there are so many district courts, so many high courts, and so it is quite difficult for any government or judiciary to coordinate and bring all of them in one national grid. So I don't think it has taken much.
There is a question that constitution of e-hearing before judge at the first time if network problem whether the matter will be dismissed or adjourned.
Now see, in Delhi High Court, there is a helpline number given, and if you face any difficulty while arguing the matter, if there is a discontinuation of internet or electricity or anything of that sort, you can telephonically inform the registrar who is dealing with these matters, and he or she will convey it to the presiding judge, and the case will be adjourned. No final disposal, no adverse order will be made in such situations.
Okay. Then another question is that e-moot court competition in law school is really a fantastic idea. Yeah.
Thank you.
Compliments. Then is there any conduct for hearing in the Indian Supreme Court? That lastly we got a judgment that a lawyer wearing banyan come to the court, trial court, e-court. Then is there any conduct for lawyers? Rule of conduct?
No, see, it happened in Rajasthan. It was an unfortunate incident. It happened in Rajasthan. But yes, we are dealing with the people, and such awkward situation do come. And I think the court has appropriately adjourned the matter for the next date of hearing and has, advised the counsel concerned to wear appropriate robes and come before the e-courts.
Right. Is there any chance for partiality in e-judiciary?
No, there is no question of any partiality because both the parties will be there. You cannot, independently, you cannot go alone, file your case, get an order and come back. As I said, you have to service the copy to the other side. The other side will be present. As I said, the registrar and the court staff are, going to the extent of ensuring over phone that if they are in receipt of such document or not. Only after ensuring that there will be e-courts, there will be videography of these proceedings. So there is no question of partiality.
In e-judicial system, we are connecting with the court, or this is a very vast information technology needed. So there is another compliment is that it increases both efficiency and accountability of judicial system.
Right, that's true.
And another here is the question that actually we want to say that we are going to start a new era of judicial system, and we need to follow yours, and we need to follow the other countries.
Mr. Parvez Rana, now Mr. Farhaduddin Bhuiya, the practicing advocate in Bangladesh Supreme Court, is with us. He was the filing lawyer of a particular writ petition where that writ petition was connected with the establishment of e-judiciary. Now, I would like to connect with Mr. Satya to have some questions from him about the judicial system. Hello, Mr. Farhaduddin Bhuiya. How are you? And welcome
Hello, everyone. It's a very nice initiative taken by all of you, and very nice to see you, Mr. Satya Ranjan, advocate
Thank you. Same here.
High Court. Most welcome. And
Thank
I
you.
was enjoying your nice delivering regarding the e-judiciary and so on. However, in the last couple of months, there had been, very well that the COVID pandemic situation in our country and throughout the world, the judiciary is likely to stop and blocked down. So in that extent, what India is doing, we are appreciating, and we need to work forward in that extent. And what I need to mention here is that in January in 2020, I filed a petition before the Honorable High Court Division of Bangladesh Supreme Court, and the court passed an order of direction to introduce e-judiciary and e-courtrooms throughout the country. However, so as you are experiencing on that matter right now, so what are the difficulties you are facing actually while working on that matters? More particularly, the technical difficulties. All the learned advocates, all the judges, honorable judges are well acquainted with such kind of deals, or no, that has to be clear for the learned advocates of Bangladesh also. Would you please clear it?
See, we are also doing it in a large scale for the first time because of this corona thing, and difficulties with regard to the technical difficulty, yes, sometime it arises. And because just now, an hour before, I came to know that there is one case filed, and when the council is ready for hearing, unfortunately the document could not be uploaded. So this is a technical aspect of it. And apart from the technical aspect, as I have discussed earlier, in terms of criminal justice system, there are different stages of hearing which are very important. For example, the presence of witnesses, the presence of accused, which is essential. But in case of e-judiciary, it becomes a difficulty. So this is what I was saying.
Right. Is there any latches or the drawbacks in regard to the wake up? I mean, some intellectual or the intelligent hackers try to hack such kinds of valuable devices or the websites.
Can you repeat the question once again? I couldn't hear you properly. Can you repeat it once again?
I want to say that. Yes, certainly. I want to say that, is there any possibility of being hacked by the hackers at the time of hearing for documents or any other evidence, if all these are distorted? Or is there any possibility that you are doing in India? Have you faced such kind of things?
No, till now I have not faced any such instances. But in Delhi High Court,
cyber security is mostly needed. So is there any threatened that you have faced?
No, I have not faced any such. But what I am saying is, in the e-court facility. As in High Court, the software that is being used is of Cisco WebEx, and there is a less chance of any security theft in such software. Yes, there is a possibility of there can be no one can can you hear me?
Hey, certainly.
Yeah, what I am saying is there is a possibility of this security theft, but as of now we have not witnessed any such.
Right. Delhi High Court Bar Association has arranged any training program, or Indian government or the law ministry has arranged any training program for the learned advocates or the judicial officers to conduct such kind of new things that you are dealing with right now?
Yes, the High Court Bar Association and the different other legal organizations and the lawyers body, they do organize such conferences and seminar to acquaint the young advocate or those who are interested in knowing the intricacies of this system. And there is a large participation of people in such programs, and I believe they are doing quite well.
A virtual court or the e-judiciary doesn't actually mean the submission before the court. So when taking the evidences from the witnesses, so are you following such kinds of things? I mean, the concept of e-judiciary or not in India?
No, see, at the present time, we are not going for the evidences, recording of evidences via virtual courts. But yes, if there is if both the parties are consenting to go for the examination of the evidences via e-courts, of course they can go for it. But as of now, we are not doing it. And in this situation also, if both the parties are willing to go for a examination of witness or examination of any document, they can go to the court. By maintaining the social distancing, they can do all this.
That means
Mr.
that,
Satya, we have a question from one of our audience. That is Mr. Qazi Akhtar Hussain, who is also a practicing advocate in Bangladesh Supreme Court. He did the question enumerating, however, do the lawyers need to wear a conventional dress, e.g., black coat, gown, etc., or formal dress like coat tie is enough?
No, for the lawyers, it is mandatory to wear the complete uniform with the robes and the gowns. It is, but it is not the same with the judges. The judges can wear formals, but the lawyers have to wear the complete robes.
We have another question from Suborno. That is, couldn't the court face a privacy threat because of the e-judicial system?
The privacy threat?
Yeah, please see the question. Maybe it also showing in your mobile also. Just I'm saying once again, that is Mr. Suborno, another practicing advocate in Bangladesh.
All right, I saw that.
Couldn't the court face a privacy?
All right, I saw that.
Yeah.
Yes, there is an issue of threat to privacy, and that is one of the reasons for not taking, for not making the entire court a e-court and dispensing the physical presence of the judges and the counsel in the court. Privacy is one of the issue there, and in case, but you must agree one thing also, in cases of vulnerable witnesses and the child witnesses, when in the physical court, there might be a chance of influencing the witnesses or threatening the witnesses, but it is not possible in e-courts. So yes, there is a threat of privacy, but at the same time, there are good things also.
Another question we have, Mr. Advocate Ruhul Amin has said, that is not only in criminal cases, but in our country, in civil suit, so many witnesses, evidences are required in both oral documentary in such situation. how the court, without physical appearance, the civil suit will be decided.
No, what I am saying is, for the civil suits, the court is not doing the complete examination of the witnesses and the documents in a virtual court. But what I said just now, if both the parties are willing, they can go for the e-court thing. But if they are not willing, the court is obviously there for them.
Thank you. Another question. Now it is already 39 minutes ago, Akhtar bhai. So, however, Mr. Kazi Akhtar Hossain has requested you just in a very briefly. Could you please tell us about the within just 2 or 3 minutes about the virtual court system in Delhi High Court? In very briefly.
Virtual system in Delhi High Court.
Yes. Virtual court system in a very brief manner, just within 2 or 3 minutes, for the betterment of our audiences.
Before that, I would like to ask you another question to Mr. Satya. Do you use any evidence camera in Delhi High Court at the time of evidence taking? It is widely used in developed countries. So far as I know, the evidence camera, which converts the paper document or the deposition of the witnesses in a JPG file or the PDF format, and it can be stored for a long time and it never be distorted in any situation. Do you use that in Delhi High Court? Evidence camera?
No, there is no evidence camera as such. But for the e-courts, what we do is we scan the document and place it before the court for the evidences. There is no evidence camera as such.
All right. So for the criminal cases, I'm telling you, the parties, attendance, or the hazira, whatever we say, do you use the biometric system of maintaining the attendance of the parties or the accused in the court?
For every day of hearing?
For every day of hearing, for example, the attendance of the advocates, all the accused, all the concerned parties, defendant or plaintiffs, do you use the biometric attendance? Not exactly.
No, there is no such biometric attendance necessary.
Can I say you are using virtual court system, not exactly the whole, but partly? Is it right?
No. See, what I have said is, we have not made the entire court system. We have not converted the entire court system into a e-court system. But yes, to a different level, to a greater extent, we are using it. And at this situation of this pandemic, we are completely using it.
Right. Okay, thank you.
Now
you can turn to your another point that my learned friend Masum requested you to talk about the brief scenario that you are experiencing here in context of e-judiciary or e-courtroom in Delhi High Court. You can tell us briefly.
No, do you want me to specifically say with regard to the present situation, because there is a national lockdown here in India, and yes, exactly. but still we are having.
You may tell about that. You may talk about that.
All right.
Regarding the present situation, how you are conducting your cases by using the virtual court system in Delhi.
I got your question.
Just one. Yes.
So see, on 4th of April, the court has said that only the cases which is extreme urgent matters will be heard. Now on 22nd of April, the court has said that even the urgent matters will be heard, and the court has categorically stated how to go about it. The court in its order has given a link that if you think that your case is urgent in nature, you can email one-page application stating your urgency to the court. it will be sent to the registrar, who will who will look upon your application, and he may allow it or he may decline it. If he declines it, then you will get a notification in your mobile phone that your file is being, your application is not accepted. And there is also an option that you can click for that option and request the application to be looked upon by the presiding judge also. And after the but you have to do all these things before 3 a.m. And if the judge allows you to file the case and get the matter listed, then within 2 hours you have to send all the documents via email. And after receiving all these documents and annexing the proof of service to the other side, the matter will be listed before the court, and the registrar will send you a SMS stating the time, and the link will be given, and you can avail the facilities of WebEx and join the video conferencing. And in case you do not have the video conferencing facilities with you, in the High Court, we have 2 courtrooms specifically dedicated for this video conferencing facility. You can go to the High Court premise, and while ensuring the social distancing, you can join the video conferencing. And the courts will hear the matter and dictate the order, which will also be given to you online. So this is how we are conducting the cases at the present time here in Delhi High Court.
All right. So one more question that I need to clear it from you. Do you follow the affidavit procedure in this system while submitting your petition, as you don't have the physical access to go to the court? So you are submitting your documents or the petitions or something like that through email or the virtual system. So when the order would be passed, how you will probe, or that you have to probe before your lordships or the court that your documents are genuine at all? Is there any procedure or the formalities that you maintain to prove it at all?
All right. As far as affidavit is concerned, as I said, Delhi High Court is one of the leading high court, and it is one of the most progressive high court in the country. So seeing the situation in hand, the High Court has dispensed with the system of affidavit. You need not go for any notarization. You need not go to any oath commissioner to get it attested or notarized before filing the same before the High Court. So the entire system of affidavit is dispensed with. Yes.
That's fantastic. That I would like to know. Fine. Another thing, if
you have another question, okay, carry on.
I have another question to Mr. Satya. When dealing with your virtual court, so can more than one learned advocate participate?
Yes, they can participate, but they have to have a separate application, separate WebEx application in their system. And suppose, for instance, there are more than one counsel for one of the party, all of them can plead, but they have to follow the system of one after another.
That we follow actually. So what we have learned from you is that you are following the virtual system in Delhi High Court, and you are getting rid of the COVID-19 pandemic right now. So the idea and the experience that we got from you deliberating today was very fantastic, and thank you very much for your nice deliberation and information communication to all of us. Hope we will be very soon connected with you. Though I have to very often go to Delhi in the Supreme Court of India, very often I have to go, have a good number of friends over there. So if I can manage my time, and if the pandemic gets stabilized, then I will certainly try to meet with you in person. Thank you.
I would also love to meet you.
Thank you.
Thank you, Farahuddin Ahmed Bhai, for joining with us and enlightening our discussion today. And we feel
Thank
proud
you,
to introduce.
everyone.
We feel proud to introduce you with Mr. Satya Ranjan Swain. We feel very proud to have you, because you were the one lawyer who filed a writ petition before Bangladesh Supreme Court, and the Supreme Court ordered rule, and after that
Direction.
the judicial rule and direction, and after that we become so much dreamful that someday we will will get the judicial system in Bangladesh. So thank you so much for Mr. Farahuddin.
Thank you so much for your nice compliment, and it was a very nice arrangement. And I think that Mr. Masum will continue such kind of initiative for the greater interest of the learned advocates throughout the world and throughout the country.
Yes, we will try, inshallah. That's today. Today our guest was from Indian, one of the Indian High Court, that is Delhi High Court, and our other guests will be from Sri Lanka, Pakistan, UK, and USA. Will try chronologically one after another. Thank you so much, Farahuddin Bhai, for joining with us. Hope you will be our future guest also. Thank you so much.
Thank you so much.
Okay, then Mr. Parvez Rana and Satya Ranjan Swain, it's our pleasure to have have both of you with us, and especially Mr. Satya Ranjan. We have got some tremendous ideas about the judicial system you were running in Delhi High Court, in India. So hope a lawyer practicing in Bangladesh, and especially in Bangladesh Supreme Court, will get tremendous ideas about how we were running your judicial system. And thank you so much. Thank you so much again. And just keep in touch with us so that we can have some great ideas from you regarding the judicial system in Bangladesh. Thank you so much.
Thank you
so much
Thank
for
you.
joining with us. So, dear viewers, thank you so much for joining with us today. Tomorrow or day after tomorrow, we will try to brought another guest from another country, and we'll try to upgrade our program also, inshallah. Till then, thank you so much. Allah Hafiz.